Public Affairs Department of the Hawaii Educational Television Network presents Hawaiʻi Report. Tonight, a look at the Constitutional Convention. What has been accomplished? What remains to be done? Your reporter, Bob Miller.
Tomorrow morning, the Hawaii Constitutional Convention of 1968 will meet to make its final decision on amendments to the state constitution. The 82 delegates will also deliberate the manner in which all of the amendments acted upon during the past 10 weeks will be presented to the voters of Hawaii for ratification. Tonight, HETV presents the first of two programs which will attempt to describe the functioning of the Constitutional Convention, how it went about its work, debate on some of the major issues, and the decisions reached. This was the second Constitutional Convention of Hawaii in this century. The first was held 18 years ago in the old Armory building at the corner of Hotel and Miller Streets, just south of Iolani Palace, where the new Capitol stands today. It was 1950 when Hawaii was still a territory of the United States, and most public thinking was that Hawaii would become the 49th state. It didn't, of course. Alaska was the 49th and Hawaii the 50th due to congressional maneuverings which some say were necessary for either territory to gain statehood. The convention of 1950 began its meetings in April. The 63 delegates working in their committee meetings and as a committee of the whole through July. After a recess for a week or two so that a delegation could visit Washington to push the statehood cause, the convention finished up its work of writing a convention in July. The delegates, with just two absent, posed on the front steps of Iolani Palace on the day they were to sign the finished documents. The signing took place in the throne room of the palace. Convention President Samuel Wilder King on the right, who would later become territorial governor 3 years later, was the first to sign. At his side was Convention Secretary Hebden Porteous, who would become president of the second convention 18 years later. The vice presidents and major committee chairmen looked on. The completed document with its 61 signatures was taken to Washington by a special delegation headed by King and Delegate to Congress Joseph Farrington. It was presented there to Secretary of the Interior Oscar Chapman. He's on the right. The Constitution written in 1950 didn't take effect until Hawaii became a state in 1959. It has changed slightly since through amendment and a Supreme Court ruling in 1964 that the legislature's Senate was malapportioned. The courts directed a change. The people of Hawaii approved calling the 1968 convention, which began meeting on July 15th in the McKinley High School gymnasium, which would be known for the rest of the summer as Convention Hall. Hawaii Chief Justice William Richardson administered the oath of office to the 82 delegates who had been elected by the people in a special election in June.
Raise your right hand and repeat after me. I do solemnly swear that I will support and defend the Constitution of the United States and the Constitution of the State of Hawaii, and that I will faithfully discharge my duties as a delegate to the Constitutional Convention of Hawaii of 1968, to the best of my ability, so help me God.
Convention Hall was hardly designed for that kind of business that it would see in the 10 weeks that followed. It was a big room with acoustics better designed for basketball games than for brilliant debate. The expansive bleachers, unfilled even on opening day, were almost entirely empty during the rest of the summer. Nor was the building air-conditioned. It never was really comfortable, despite a dozen or so fans whirring busily in corners of the room. But Convention President Hebden Porteous was coolly confident as he took over the gavel from Acting Chairman Jack Sua and outlined to the delegates the work of the convention.
The convention will please come to order. Mr. Governor, Your Excellency, most distinguished guests, delegates, and people of Hawaii. First, let me thank Delegate Sua for a wonderful job in getting this convention off to a grand start, and also to those very wonderful people who were so complimentary in nominating me as president of this convention. I'm also deeply indebted to the rest of you because I know kind words do not an election make. Hawaii is a unique blend of people, of land, of attitude, of sea and sky, a series of islands squeezed from the inside of this earth in the middle of this mighty ocean, later known as the crossroads of the Pacific, but more distinguished as a demonstration of living and working together of people in harmony to their mutual advantage. It's a home of a gracious and very friendly people, the Hawaiians, who welcomed others of many races and are joined with their hopes and ambitions and talents in developing Hawaii and our way of life. Nowhere in the United States was a history of government similar to ours. First islands with individual chiefs, then unification under the mighty Kamehameha I, an absolute monarchy, followed by constitutional monarchies. There was a great mahele, where there was the division of land between the royalty, the government, and the people. Later there was a Republic of Hawaii, which negotiated a treaty with the United States so that we became a portion of the United States as a territory. Later we achieved statehood and became a sister in the Sisterhood of States. This was achieved by the people of Hawaii through their manner of life, their institutions, and their devotions and sacrifices in war and in peace. Hawaii is all that took place in the past, the present, and the promises and the threats of the future. These delegates have been specially trusted by the people of Hawaii, selected to review our Constitution and our government, a framework to enable people to advance their welfare and enact laws for that purpose and provide solutions to varying problems as they deem from time to time to be in their best interest. It is not for us to impose our will on the future and unduly hamper experimentation and change, though at present we would not adopt or approve such change. The power to enact laws, to efficiently plan, to administer government, and to enforce laws as well as provide timely and equal justice under law for all should be broad. You delegates know laws are made by, administered, and enforced and interpreted by people to advance the interests of others with due protection for any minority. The delegates here hope to work efficiently, effectively, and harmoniously in the interest of all the people of the state. The result will best be judged not by the amount of change, but by the careful study, thought, and sincerity of purpose of you delegates. May your efforts be judged to be in the high tradition of those who have served Hawaii so well, and be in keeping with your high resolve, your talent, and your ability.
On that July 15th, there were few close to the convention who expected any major reworking of the Constitution of Hawaii. There were indeed some who saw in the legislative act setting up the convention a deliberate effort to guide the delegates away from the path of radical change because of certain built-in time limits. And the election of June 1st, with less than half of the electorate going to the polls, produced a delegation heavily weighted toward the status quo. It was in that direction that Governor John Burns pointed when he addressed the delegates on that opening day.
I desire also to take advantage of this opportunity to extend my personal congratulations to each of you 82 citizens of Hawaii who have been elected as delegates to our second Constitutional Convention. It is indeed a distinct honor to be invited to address you today in your inaugural session. It is a high privilege and a great pleasure to be with you. It is noteworthy that this convention has been brought about in the time-tested manner traditional to our representative form of government. Each of you holds a high trust placed in you by your electorate. I share in their confidence that you will, during the course of this convention, dedicate all your energies and abilities to further ensure the preservation of our democratic form of government and its proven institutions. It has frequently been noted that our state constitution a document agreed upon by delegates to the first convention exactly 18 years ago next Monday, is fundamentally a sound and up-to-date political instrument. This has been noted this morning in the proceedings. As a matter of fact, our Constitution is looked upon as a model by many other states involved in similar conventions. I share the view that we do have an excellent Constitution. The delegates who fashioned it in 1950 did a most creditable job in preparing for the sovereignty accorded to us 9 years later. We are fortunate to have among your numbers in this convention several delegates who participated in that first convention. And may I express a personal pleasure also at sharing with you the title delegate, because it is a most honorable one and a most historical one in these United States. The experience of those among you who have served previously will be most highly valuable in your deliberations. And while our Constitution is sound in most respects, it will not suffer from further refinements. Meeting in convention as you are, all points of view can be explored to produce the necessary changes. Reapportionment of our legislature, the original impetus for calling the convention, is, of course, the major issue confronting you. Other important questions which will surely merit your consideration for possible amendment are the strictures in the state debt ceiling and judicial tenure. But I do not intend to belabor you with a recitation or a dissection of these matters which rest ultimately in your judgment. Nor is it my intent to offer inspiration, for this surely will come from within. Nor do I presume to counsel you, for you will find many, I am sure, eager to counsel you in the succeeding days. Moreover, in the final analysis, each of you is and will be his own counsel, which is as it should be as elected delegates representing the voters of this state. What I should like to leave with you today is a reminder that you will be reviewing and considering changes in the basic political document of our state, the highest law of our islands, our exercise as citizens of our sovereignty. Policies as expressed in legislation and in executive decisions are always subject to change to meet the needs of changing times and changing ways. Principles, however, remain immutable, and it is basically an expression of principles which will guide the substance of the Constitution's provisions. The subject matter in your hands is at the heart and at the very foundation of the institutions by which our society is organized and by which it lives. You have, therefore, the highest challenge before you to refine a document which will ensure a better Hawaii for all our citizens for today and for tomorrow. Your deliberations and your decisions will be of vital importance to the future course of our state and our people. There will, I am sure, be times of difficulty in reaching agreement on what avenue is best of troublesome issues. At such times, perhaps you can take heart in being reminded of the troubled road that led to the drafting of our nation's Constitution. I'm indeed delighted to see that we quoted the Democratic Republican Thomas Jefferson this morning. It started, as you know, with a revolution and then proceeded through a number of ineffective attempts to devise a new government for our states, including the Articles of Confederation, which functioned so badly it began to appear the revolution had been fought in vain. And finally, there was the Constitutional Convention of 1787. But even then, there was no end of disagreement. Many compromises were necessary before the venture could be brought to a successful conclusion. Then, as the last members were signing the Constitution, Benjamin Franklin, looking toward the president's chair, at the back of which a rising sun happened to be painted, observed to a few members near him that painters had found it difficult to distinguish in their art a rising from a setting sun. I have, Mr. Franklin said, often in the course of this session and the vicissitudes of my hopes and fears as to its issue, looked at that behind the president without being able to tell whether it was a rising or a setting sun. But now at length I have the happiness to know that it is a rising and not a setting sun. I share in Mr. Franklin's view that things are looking up, and I further share in the people's expressed confidence in your demonstrated dedication to building a better Hawaii. As Chief Executive, I welcome you to meet with me at any time that you feel necessary, and I stand ready to assist you in any way the executive branch can to make this convention the success it deserves to be. My very best wishes for a most successful and fruitful convention.
Majority of the delegates appeared to agree that the convention could wind up its work before the start of the fall term at the two schools which housed it, Kapiolani Community College and McKinley High School. Delegate Bill Harper, though, wanted to be sure that that would be possible.
At least one resolution for introduction.
Mr. Chairman,
Delegate Harper is recognized.
I had a little problem with semantics. I don't know whether I have a resolution or a proposal. Mr. President, in accordance with Rule 34 of the Rules of the Convention, I move to amend the rules as follows. After Rule 66, insert, quote, Rule 67. The convention shall complete its deliberations in not more than 45 calendar days.
The chair will treat this as a resolution. The Sergeant of Arms will pick up the matter in writing that the delegate has.
The clerk has it, Mr. Chairman.
Clerk has it. Then under these circumstances, the chair will refer this resolution to the Rules Committee for its consideration.
The resolution languished in the Rules Committee of the Convention until last week when the committee filed it along with other pending matters, for of course the convention didn't finish in 45 days. Classes were delayed by a couple of weeks at the Kapiolani Community College, where the delegates were housed in this business education building and where most of the committee hearings and meetings were held. The first month of work of the convention was devoted for the most part to these meetings as the convention standing committees heard testimony and considered the more than 300 proposals for changes to the Hawaii Constitution. One of the first decisions the convention had to make was whether we should keep our present bicameral legislature or change it to a unicameral body. Chairman Richard Schultz of the Committee on Legislative Apportionment and Districting explained to us why this early decision was necessary.
The process of apportioning and districting is really the process of allocating representatives or allocating legislators out among the various political districts. Before you can actually sit down and start drawing lines on a map to decide what your districts are going to be and making decisions as to how many legislators each particular district is going to have, you've got to make some preliminary decisions, obviously. Many of those decisions have to be made by our committee, but one of the decisions that we thought would be very helpful would be the decision whether we're going to have one house to reapportion or two. It would be helpful if that decision could be made early, but it's not entirely essential that it be made immediately. Let me put it this way. We have to make such decisions as what will we use as a population base? Will we use registered voters, or will we use population, or will we use adjusted population figures, or would we use a figure called state citizens, if we could define that? This decision can be made without regard to whether we have one house or two houses in the legislature. We've got to make other decisions too. We've got to decide whether we want multi-member districts as we have now. For example, in the House and Senate, almost all of our districts elect more than one representative or senator. Many have suggested that we should reduce this to single-member districts, or we should reduce the size of the districts. It's helpful if you know whether you've got 2 houses or not to make this decision, but it's not essential. We could actually make it in a kind of abstract way and still wait until the actual decision on single house or double house is made. But when we get to the point of sitting down with a map and drawing lines and making the adjustments that we have suggested, then we've got to know. We've got to know whether we've got to make one set of lines for a House of Representatives and another set of lines for a Senate, or whether we're talking about just one set of lines covering both houses.
Well, are you taking steps to make a kind of a determination of this relatively early in the convention?
Yes, the other legislative committee has indicated that they'll take the matter up first.
They're the ones who have the responsibility for doing the work in this area, is that right?
That's right. It's one of those funny things. It's hard to divide the legislative committee into 2, which is what we did, but there was so much work that we had to do that.
That other committee, the Legislative Powers and Functions Committee, headed by Hung Wo Ching, considered the unicameral bicameral question for a week or 2 while it went about its other business. It decided with only one dissenting vote to recommend to the convention that the present bicameral legislature be kept in a consensus vote. Later, Chairman Ching told us about the committee's decision.
After much discussion and after every member of the committee had an opportunity to cross-examine the witnesses, we took a consensus of opinion whether or not the committee members have decided or are inclined toward a unicameral House or a bicameral legislature. And the consensus of an informal opinion is one of unanimous choice for a bicameral, excepting for one delegate.
Right. Does this indicate that this is the end of this subject, that it's settled now, or what's going to happen next?
We will not come to a formal decision until the 5th of August, when the delegates now visiting the neighbor islands will return and attend a meeting. But with such a substantial majority on the committee in favor of bicameral legislature, I can take the reading and presume that this will be the decision for them to recommend to the committee as a whole.
The delegate who voted against it was Leland Larson, but there was another member of that committee who opposed the matter too, and that was Nelson Doi. The committee's position had been solidified after that unscheduled vote, that consensus. It was described by Chairman Ching. Doi was busy with other convention business at the time, was not present for the first committee vote. Later, and before the question went before the committee of the whole, Doi talked with us and questioned the procedures followed in handling the proposals for a unicameral legislature.
We did not expect the question to come up that morning. In fact, we were made to believe that that morning the delegates in the convention who wanted to testify on the question would be allowed to testify, but that the committee would not be asked to indicate a consensus vote. And we're quite disturbed about that, because whether it's formal or informal, when you indicate your position on a call for a consensus vote, the only thing you can indicate is what really you're thinking, and it's quite official, I would think.
Or do you feel that free and open discussion has been hampered by this kind of operative technique?
Somewhat on this question, yes. On this question, somewhat, yes. In fact, what disturbs me, and I think it's of concern to many of the delegates here, is that quite a few of our fellows in the convention have come to the convention with positions already fixed on some of the major questions. Now, I don't think any delegate at the convention can say that he was so well informed before the convention convened that his position is closed, it's fixed, that he would not open his mind to further exploration. This is kind of a sad state of affairs, I would say. I have strong tentative positions, and I expect to be challenged on them, and it should be, vigorously. But I have an open mind on all the questions, and I would like to explore all the consequences, the ramifications of particular issues. When it comes to the unicameral, bicameral question, I think even if we know that the vote is going against the unicameral system, I think we owe a duty to the people and to the convention and to the record to fully discuss this question. I am still convinced that the unicameral system is better for Hawaii.
Well, there isn't a closed door yet. You will have an opportunity to discuss this on the floor, won't you?
Yes. When the Committee of the Whole meets to consider this particular proposition, we have been assured that this question will be given an opportunity to be thoroughly examined.
From a reasonable and practical standpoint, do you consider that it would be possible to change the course of the course that events seem to be taking at the present time? That is there still any hope for those who stand for unicameralism?
No, I think the vote will go against the unicameral system and will be in favor of the bicameral system. But I think it's going to be awfully hard and difficult and even embarrassing, I think, for fellows who are in favor of the bicameral system to justify that the bicameral system is better for Hawaii. A lot of words are going to be used, but I think when we get into a very close analysis of the reasons, it's going to show up that the unicameral system is a better system for Hawaii.
Convention leadership decided to settle the question early so that all of the committees concerned with matters related to the legislature would be able to get on with their work. And since it was to be the first wide-open debate of the Constitutional Convention of 1968, President Porteous detailed the procedures to be followed in the Committee of the Whole several days before the event.
After consultation with the chairman and the members of the committee having charge of unicameralism and bicameralism, I inform you that there will be a resolution that will reach this floor, we believe, tomorrow morning. It will then be referred to the Accounts and Printing Committee. But you are all put on notice that on Saturday morning, within the session time, this body will convene itself into the Committee of the Whole for the purpose of discussion of this and for, hopefully, action that morning with a report back to the body on Saturday morning. So those of you that wish to participate in that debate have now the notice from Wednesday, Thursday, Friday, that on Saturday morning the subject will be considered. Are there any announcements?
Mr. President?
Yes, the Secretary is recognized.
Mr. President, I think it should be noted here that this is a special kind of resolution that you're talking about.
That is correct. Thank you very much. This is not a matter of going into the Constitution at present. If the principle of bicameralism prevails, it is only in effect a guideline to various of the committees. If the principle of unicameralism were to prevail, again it would be a guideline to the various committees.
Well, after 3 hours of debate on the following Saturday morning, the delegates voted by large majority to sustain the committee recommendation to keep things as they are with a bicameral legislature. It was an indication of what would happen to most of the proposals for radical changes to the Constitution in the weeks ahead. Committee on Taxation and Finance added a lot of new words to the Constitution by the time that it had finished its work, but did more to change procedure than substance. After the convention had been meeting for 2 weeks, Chairman Thomas Hitch told us what his committee was doing and planning to do.
For example, we've heard from a good many business organizations. We have yet to hear from the labor unions, whom I've invited. We've heard from a good many government people like Andrew Ng of Budget and Finance, and Clinton Tanimura of the Legislative Auditor, and various others. We have a man coming out from New York to appear before us on Thursday, Mr. Joe Vostel, who knows Hawaii and knows Hawaii's finances very well. He's been out here on a number of occasions. He's the municipal bond analyst for Kidder Peabody. We've also been in touch by correspondence with Moody's, Standard & Poor's, Dun & Bradstreet, the rating agencies, and also with a good many of the main municipal bond analysts in New York and in San Francisco to get their opinions about appropriate debt limits and other financial matters.
The matter of debt limit is one of your major matters of concern, is it not?
Debt limit is one of the major matters of concern, but we're concerned with the entirety of Article 6. Article 6 deals with taxation and finance, and so it involves other issues such as the vesting of taxing power, whether it should be entirely with the state or whether it might be partly shared with the counties. It involves limits on taxing power. It involves, of course, the debt limit, which I mentioned. It involves budgeting and budgeting procedures and appropriation procedures. It involves the office of the legislative auditor as well.
When Andrew Ng, the director of finance of the state, was testifying the other night before your committee for, I guess it was over 2 hours, 2.5 hours or so, he recommended that the present limitation on debt be done away with and no new limitation be placed there. Has there been any sentiment from members of your committee as to accepting or rejecting this recommendation?
There is one proposal that one delegate, who happens also to be a member of my committee, has put into the convention, which would provide for no constitutional debt limit.
Do you anticipate that this, or can you say?
Well, I really don't want to anticipate too many things at this point. But while I don't want to, I think this is probably going to be a minority viewpoint.
Chairman Hitch's committee finished up its committee proposal and 2 weeks ago saw it accepted by the Committee of the Whole. The long and highly technical proposal does three things, basically. It provides for an increase in both state and county debt limits, but relates the state's debt limit to general fund revenues, where the state gets most of its income, rather than to real property taxes, which all go to the counties. The proposal also provides for the return to the biennial budget, with provision for an annual review. And the proposal eliminates a section having to do with equal taxation for non-residents, a right already guaranteed under both the federal and the state constitutions. Some of the most controversial proposals to come before the convention were referred to the Committee on Public Health, Education, Welfare, Labor, and Industry, including collective bargaining rights for public employees. The chairman is Bob Tyra.
Sections themselves are quite brief. They're general guidelines, and they're not restrictive at all. And at least in my case, I campaigned for this convention on the basis that there are not that many major issues to be resolved at this convention. I think you know as well as I do that reapportionment, the type of legislative sessions, maybe the judiciary, the voting age being lowered to 18, and collective bargaining for government employees. These are the major issues.
Well, collective bargaining for government employees is a matter which is coming before your committee.
It's coming before my committee.
When are your hearings on that going to be?
We'll begin our hearings next Monday afternoon. That's August the 5th or the 6th, I don't recall exactly.
5th, I believe.
5th. What I plan to do, I'd like to have our Attorney General's office send their legal experts to explain to our committee members just what collective bargaining as used in our Constitution means. Because without an understanding of the meaning and detail of collective bargaining for government or private employees, our committee members will have a hard time making a basic far-reaching decision.
The present Constitution provides collective bargaining for private employees, but not for public employees.
No.
It says they may organize
they organize, they may present grievances, they may negotiate for better working conditions, but the term collective bargaining is not used at all in connection with government or public employees.
The problem deals with the matter of whether they have a right to strike, essentially.
I think that's going to be
whether or not they have the right to strike.
The issue.
But there isn't any statement in the Constitution that guarantees private employees the right to strike, is there? At least in that section, there isn't.
No. My understanding is that in Section 1 of Article 12 of our Constitution, dealing with organization and collective bargaining, the statement is something like this: people in private employment shall be guaranteed the rights of collective bargaining, period. And in Section 2, it goes on to say people in public employment shall be granted the rights to organize, to negotiate, present grievances, but the term collective bargaining has not been used to apply to them, you see. Now, I also understand that under certain judicial opinions that have been rendered, that whenever you apply the term collective bargaining to employee rights as such, it's understood that they have a right to go on strike. And this is the thing which is being discussed among the 83 delegates as to, well, now, are we going to give public employees the right to strike or are we not?
Well, the convention decided by not deciding. It did adopt a proposal to allow collective bargaining for public employees as provided by law, the proposal read, so that the legislature will still have the final say as to whether government employees can have the right to strike. The convention turned down all proposals for changes in the health, education, and welfare articles, including a guaranteed annual wage, tuition-free higher education, and even the committee's proposal that school advisory councils be provided for in the Constitution. All of those were turned down. Big Island delegate John Ushijima is chairman of the Committee on Local Government. Oahu delegate Pat Psyche is vice chairman. Early in the work of the convention, they explained to us their committee's job.
Pat and I actually stated to the committee our philosophy is that we're entering into this whole thing without any preconceived ideas. Like the rest of the members of the committee, we want to start from the bottom, get as much information as possible, and as I indicated, we're still in the process of trying to get as much information as possible. So it's pretty hard to answer at this point whether there will be any drastic or basic changes made.
I think, however, that the whole area concerning local government is such a completely open one, and there have not been as many guidelines set by the previous convention, that perhaps this is an area that will render serious consideration, and I think John and I are aiming for complete total deliberation and consideration for stronger home rule or better coordination between the state and the counties.
Well, we understand. We were just reading through it. In fact, one of the delegates to the convention has sent a memo around to his fellow delegates urging that due deliberation be taken in the convention and expressing a concern that perhaps the delegates are looking into the minutiae of legislative matters and not concerning themselves with really constitutional questions. Do you agree with the sentiment of Delegate Dodge?
Well, I believe he's correct. I think that we seem to lose track of what we're here for. And basically it is to look at the Constitution without getting involved in lots of these legislative matters. We're concerned with the basic structure for the state. And I don't believe that we should burden the Constitution with lots of trivia and get into specific details. Those I rather leave to the legislature.
As for local government, the convention ended up by giving the counties half a loaf. They will be able to adopt charters without having them ratified by the legislature, but they won't have residual tax powers that they had asked for. The question of how Hawaii's judges should be selected got more public attention than any other matter before the Constitutional Convention. Both daily newspapers editorialized in favor of the Missouri or Commission Plan, which is also called the Merit Plan, and a Citizens Committee conducted an extensive publicity campaign in favor of it. Both efforts probably did more harm than good for the proponents, since many delegates openly expressed concern that they were being unduly pressured to favor that side. The chief protagonists were appropriately Chairman Jack Mizuha of the Judiciary Committee and Vice Chairman Keith Steiner of that committee. Before the question came to the floor, we asked Delegate Mizuha about reports of dissension in his committee.
Well, I wouldn't say dissension. I think there is a difference in the point of view with the method of appointment of judges. And as you know, the Bar Association has a specific proposal for the establishment of a judicial commission to select judges. The Citizens Committee also has a proposal which is not as specific as the Bar Association proposal, and of course they are the proponents of the status quo. And my committee must determine which of these methods of selection of judges is the best for the people of this state.
Well, members of your committee have, not each, but I suppose many of them have submitted one or another of these versions. You yourself Chairman Mizuha submitted a version of a change of the existing judicial selection system?
No. I've just submitted a proposal for the lengthening of the tenure of the judges, as well as the reappointment by a yes and no vote on the part of the electorate. That's the only change I've submitted in my proposal.
Your vice chairman has his name attached to the Bar Association's proposal.
That's right.
Mr. Steiner, does this mean that, I noticed that it says it's by request. Do you agree with the Bar Association proposal?
With every single part of it, not necessarily. However, there were a number of people that wanted this proposal brought before the convention. It was the actual wording of the proposal that I put in had been drafted by a committee of the Bar Association, with one exception, the Section 9, which dealt with the actual setting up of the commission. There was a difference within the bar on how that should be set up and function, how it should be set up, rather. I put in the plan which called for the appointment of certain commissioners by the governor. And I did this to get the matter before the committee so we could have a free and open debate on it and select what is best for the people of Hawaii. It's my feeling we're not going to have another convention for many, many years. The Constitution provides the question of a convention will be put out to the electorate every 10 years, and they can answer yes, they wish it, or no, they don't. It's doubtful if some changes in the selection of the judiciary would be sufficient to call a constitutional convention together, say, 10 years from now. I believe the reason this one was called was because of the question of reapportionment. A number of us feel that while we are considering that question, other matters should be gone into also, and also we should look very carefully into the possibility of improving the method of selecting judges. We feel we have a very fine method now, but we're looking for possibilities of upgrading it.
There was a newspaper advertisement yesterday, a full page, calling for citizen concern on this issue. There is the editorial in this morning's newspaper calling for citizen concern, and I noticed that there are hardly any citizens attending your committee's meetings and hearings. Are you concerned about this at all, sir?
No, I'm not particularly concerned about it. I believe that there is a great deal of interest on the part of the establishment, so to speak, in amending the state constitution with reference to the appointment of judges. What I'm interested in is whether or not all of the lawyers in this town agree with the Bar Association proposal. We had a few lawyers speak in opposition to the proposal. However, I contemplate that there will be a number of lawyers who will be seeking a place on the program come August 9th, when Mr. Glenn Winters, the Executive Secretary of the American Judicature Society, presents the Citizens Committee's plan. And I hope that we can have the views of lawyers who actively practice in this city, who are constantly before the judges and justices, and who are most concerned with the selection of good judges here in Hawaii.
Now, the committee rejected the Bar Association's plan and all other commission plans. It reported out a recommendation for just 3 changes to the present Constitution: to allow the Chief Justice to have retired justices help out when the calendars get crowded, to extend to 10 years the terms of judges and justices, and to strengthen the retirement and removal provisions for judges. Delegate Steiner attempted to amend the proposal from the committee by adding a modified Missouri plan on the floor. 51 of the 82 delegates voted no. Later in the convention, Delegate Mizuha offered an amendment to the election article relating to the judiciary with an apology accompanying the amendment.
Mr. President, I offer the following amendment to the committee proposal. Number 1, this is an amendment to Section 5 of the committee proposal. It will amend the second
third sentence to read as follows: contested elections shall be determined by the Supreme Court in such manner as shall be provided by law.
Mr. President.
Delegate Kunimura is recognized.
Second motion.
It's been moved and seconded. The chair now recognizes Delegate Mizuha.
I wish to apologize to the members of the convention. My arduous duties in conducting that play, The Making of a Judge, somehow or the other occupied much of my time, and I forgot to submit this amendment. Now, if the members of this convention will go back some 2 years ago, there was another play in Hawaii known as The Making of a Governor. And during the course of the election of that governor in the fall of 1966, there arose a contested election after the election of the present incumbent governor. The defeated candidate rushed to the circuit court, which is now provided by law to hear contested elections. And it took the Supreme Court of this state almost 2 years before it had the case before it and to decide whether or not the incumbent governor was legally elected. Now, it seems absurd to have the contested elections determined in the circuit court and then through the process of appeal finally and definitely determined by the Supreme Court if it takes about 2 years. With reference to the representative whose election is contested, he might have served 1 full term and still the Supreme Court hasn't decided whether he was legally elected or not. Fortunately for the governor here, he had served 2 years before the Supreme Court said that everything that has happened since he was sworn into office is legal. I doubt very much whether there should be any debate on this subject. However, there is always someone who is questioning the offering of an amendment of the proposal, and Mr. President, I shall be happy to answer any question that is within my power on this amendment.
But the convention did not support Justice Mizuha's proposal to make the Supreme Court of Hawaii the court of original jurisdiction in contested elections, illustrating perhaps best of all that it is easier to win at the con-con when opposing change than when supporting change. But of course that was later on in the convention. Earlier, some changes were possible, and the first and most controversial one to the present Constitution was proposed by the Committee on Election and Suffrage, the proposal to reduce the minimum age for voting to 18 years. The 3 youngest members of the convention were on the committee that made the recommendation, but they weren't in agreement on the proposal.
No, that's true. I don't believe we should reduce the voting age to the age of 18 simply because of several other factors. Namely, the age of majority is still 20 in the state, as it is in the other states that have the age of 18. Personally, I feel that someone who cannot be responsible for his contracts, for his debts, for drinking and this sort of thing should not have the privilege or right of voting.
And are you in agreement or disagreement with Ms. Hansen? Mr. Larson.
I'm in disagreement with Ms. Hansen on this particular point. I do feel personally, and on the basis of testimony given to the Bill of Rights and Suffrage and Elections Committee, that 18-year-olds through 20-year-olds certainly do have the political judgment and maturity necessary to vote and to exercise this responsible function in our political democracy. So I am definitely in favor of this particular proposal.
Because this is something that you're all going to have a chance, or everybody in the convention is going to have a chance to debate about very shortly on the floor of the convention. Mr. Burgess, how do you stand on the question?
Well, I'd like to go all out when you do something, and I think if you're going to give the voting age, well, if you're going to lower the voting age to 18, then we should change the age of majority and give them all the responsibilities and the rights of any other citizen. Simple as that.
I understand also in hearing testimony, I guess it was in another committee, that you, Ms. Hansen, are in favor of having legislators be as young as 20, or even 18 if that should be the age of majority.
I feel that you have to be arbitrary about one age, and one age only. And upon attainment of the age of adulthood, which is that age, you should have all the privileges and responsibilities of being an adult come with attaining that age. That's not saying that we're going to have a whole House and Senate and a governor, all 20-year-olds, but that's saying that every citizen who is 20 years old and who is an adult should have the privilege and right of holding any office in the state. Whether he wins or loses is up to the voter, but we should not, as an elite body, minimize the voter's choice for that office.
Well, Ms. Hansen lost finally on the 18-year-old vote question, but she won on the legislative age question. In the Committee of the Whole, when the 18-year-old vote proposal was being debated, Delegate Dennis O'Connor made a strong plea to change the wording from 18 years for voting to the age of majority. The amendment would in effect have put the age question into the hands of the legislature.
The proposal to change this particular article to read that the age of majority, as established by law, shall be the voting age, should be the most meaningful and the most abiding language that we can establish at this time. And why is this? Mr. Chairman, the reason for this is obvious. The age of majority is established statutorily. It is a statutory age of maturity. There is a definition of the age of majority in the Minority Report, which is before every delegate. It's the full age, the age by which, by law, a person is entitled to the management of his own affairs and to the enjoyment of civic rights. This is an age which has been established in Hawaii by the legislature. It has been modified in Hawaii by the legislature. Prior to the laws of 1869, the age of majority in Hawaii by common law was 21. In that body, the legislature established the age at 20 for males and 18 for females. In Hawaii, those ages of majority lived until the legislature of 1919, which changed the age of majority for females from 18 to 20. And since 1919, the age of majority in Hawaii has been 20. This is an age at which a child becomes legally a man or woman. This is the age at which a child's contracts are binding upon him. This is the age at which a child can marry without having to obtain his parents' or guardians' consent. This is an age at which a child may finally dispose of his property by will. This is an age at which a child may finally, Mr. Chairman, establish his own business if he cares to. This is an age at which a child finally becomes responsible for his own torts. An age at which other men and women can look to a child and have that child stand out in the community as someone who is responsible, Mr. Chairman, able to manage his affairs legally, and by act of this state, mature in the eyes of the law. This convention would, from a legal standpoint, establish, Mr. Chairman, an age of 18 as an age at which certain civic rights are granted a child. And this convention would do that, Mr. Chairman, without even giving that child the ability to fully appreciate or exercise his right of suffrage, because that child would be unable to take himself into a court of this state and enforce his right of suffrage, or to compel by mandamus any official of this state to in any way further the electoral process.
The delegates spent a lot of time debating this question of giving the vote to 18 and 19-year-olds because they recognized that the proposal would be taken very seriously by the voters when they go to the polls in November to ratify the amendments. One of the outspoken supporters of the Suffrage and Election Committee's proposal, and also an opponent of the amendment, Delegate O'Connor, was Big Islander Nelson Doy.
Mr. Chairman, I would like to speak against the proposed, rather the amendment. I do not want to repeat again the arguments presented by the chairman of the committee in favor of the committee recommendation. I agree with them. But in addition thereto, I would like to recite another reason. Mr. Chairman, ours is a representative form of government. Our representation, we were told by the Supreme Court in 1964, must represent all human beings. All human beings, including children from the minute they are born to the time when we pass away. And if we are, Mr. Chairman, to effectively accommodate this requirement, and I believe this Constitutional Convention is of the attitude that we would like to accommodate and make effective this particular concept enunciated by the U.S. Supreme Court, then certainly it behooves us to make reasonable and responsible adjustments downwards in the voting age. It's my position, Mr. Chairman, reasonable and responsible adjustment is down to the age of 18, and you have already heard the reasons set out in the committee report in support of reason and responsibility. Now, in direct response to Delegate O'Connor, I would like to say this. The Constitutional Convention is a more basic organization than the legislature. More basic, especially from the standpoint of structuring our government. The legislature is a lesser body. The question, Mr. Chairman, of who should vote in our government is more basic than whether we should have a governor's office or not, whether we should have a legislature, or whether we should have a Supreme Court. I don't think anyone here would like to pass this question over to another body to decide for us as to whether we should have a legislature or a governor's office. It's our responsibility to meet the challenge, to decide clearly who will be the masters of the government for the state of Hawaii. It is for us, therefore, and we're under duty, to set the requirement clearly. As to the questions raised by the majority, as to the questions raised in regard to the majority age, I would say this is a lesser question. And let the lesser body decide this. Let them follow the leadership of the Constitutional Convention.
The amendment was defeated. The convention went on to approve the 18-year vote. It also approved 3 other changes in the election and suffrage article: to restore voting rights to discharged felons without special pardon, to eliminate the literacy requirement for voting. The purpose here was to allow those literate in languages other than English and Hawaiian the same rights as the rest of the citizens. It was incidentally an amendment which had been voted down by the people 2 years ago. And to authorize a presidential preference primary. The convention changed to permissive the language in this amendment, which would originally have required such a presidential primary.
This has been Hawaiʻi Report on the Constitutional Convention with Bob Miller. This program was produced by the Public Affairs Department of the Hawaii Educational Television Network.